So let's just cut right to it. I thought putting a will down was like, again, great, it's done, it's ironclad, but maybe it's not.
Well, it can be, and hopefully it is.
Yes.
But there are reasons why people might have an opportunity to challenge that will. So things like undue influence, which is the legal terminology. When somebody has maybe convinced you to do something, they've exerted influence over you, and you felt pressure to do something and maybe change a will that doesn't really reflect your wishes. They may have actual cases of fraud where it was not signed by the person, not intended to be their wishes. There could be challenges to the capacity of the individual, and this is very interesting because that's a nuanced assessment. It's not simply,
spectrum, right?
it is a spectrum. So simply because somebody has dementia or Alzheimer's does not mean that they wouldn't necessarily have capacity to have written that will.
Or intent, you're right.
That can be challenged. Mistakes. Things can go wrong. You can sign the wrong document. I've seen husband and wife sign the wrong document or not sign at all, or having witnesses not having met the formal requirements of being a witness. So lots of different ways that a will could be challenged, even it's simply unclear. People don't know what it actually means. And in those cases, people can bring a notice of objection either before or during the application for probate. And they'll typically be working with a lawyer to ask them what their options are. Now, if that will was found to not be valid, then it might result in a previous or prior will being deemed to be in force, or no will at all means now we're into the world of intestacy, where provincial legislation is going to determine how your estate is going to be distributed.
Which is what you really don't want.
We want to avoid this if we can, yes.
You have also too some notes here. I know that someone said you have something here about if it contains specific provisions outlining things like anyone who contests this will lose everything. Like what is that about?
So those are typically in situations where somebody's anticipating that people are going to be aggrieved and they're not going to be happy about this will and they're going to be challenging it. And there's language that you can put into these documents that say, to the extent any of my beneficiaries challenge my will, anything that they would have received under it will be zero. And so, of course, you'd want to get appropriate advice to make sure that that's going to be a binding clause and work the way that you want to. But there are some strategies that people can do if you expect that there might be some challenges.
And even I'm thinking that just like fathers or mothers, fathers, children, you can't do things like that if you're deemed you have to. I don't know. I'm not the lawyer. This is Nicole's laying. Let me give the legal advice. I'm sure there's lots there. Okay, can you give us though a recent example of a will being challenged?
There was a really interesting case out of BC, and it's interesting for a few reasons. A, because it really highlights the difference between provinces in terms of what would be acceptable challenge in one province that wouldn't be in another. So this case in BC was a daughter who brought a claim against her mother's estate saying that mom had discriminated against her, had left her less, significantly less, like 80% to brother, 20% to her, on the basis of gender bias. And mom had different values and put in her will essentially that daughter would receive less. She challenged that. And under BC rules, there's a Wills Variation Act that allows you to bring this claim. You don't need to be a dependent in order to do that, simply the child, spouse or child. And so that was a successful claim where the court varied the assets that the daughter received under that. Now, that same result I would not expect to see in Ontario because we don't have that wills variation language. It's slightly different, and we don't look for the fair and just result, which is actually written into the words of the BC.
That's fascinating.
It's very interesting that you could have a very different result, and you have sort of these moral claims that would be entertained in one province and not at all in another.
Yeah, so again, just making the provincial jurisdictions so important when you're actually putting these things together.
Yeah, absolutely.
Okay, so what do I do, or what does someone do who's watching this to go, okay, how do I make sure this is ironclad, or as ironclad as it possibly can be?
Well, so obviously working with a professional who can advise you about this, but there's things that you personally can do as well to make sure that you're not making this more difficult. So perhaps getting a capacity assessment in advance to show that you did have capacity if you think that might be a challenge, and you can get a professional to make that claim for you. Acting consistently, so not being flippant. There's often these jokes about, oh, I'm going to write you out of the will, or even a casual statement about what somebody might receive. And if they're disappointed when they don't receive that at the end of the day, that might be a reason why they want to challenge it.
Right.
So acting consistently, not changing your will frequently, making sure that your loved ones know what your intentions are and that there's not confusion about that, and that you're anticipating things and having up-to-date documents that reflect your current situation, so that we're not trying to guess whether or not something from from the past is still relevant.
Yeah, and anything on the different provinces too? Like I know you say that there's some other, I think, non-will strategies you can use.
Oh, absolutely. So depending on what province you're in, so this BC case,
Yeah.
for example, that was a wills variation claim. So had she chosen to leave assets in a different way, it may have led to a different result. So thinking here of use of trusts, whether naming beneficiary designations, transferring assets during your lifetime when you're not relying on a will to make that transfer, but are instead transferring it yourself. So different strategies that you might use outside of the will.
And how often should a trust be considered? Is that something that, is it special circumstances, or when does it make sense?
There are very useful tools to be able to leave assets to loved ones in different ways. And it allows you to, for example, separate when you transfer the asset from when you transfer control. So you might want to be thinking about that during your lifetime. But outside of using a trust for privacy reasons to avoid certain legislation, there's other things that you can do. So I would say almost more importantly is to ensure that the person who's administering your will has the requisite knowledge and authority and skills to be able to ensure that your wishes are actually followed through on. So naming, for example, a professional executor, a trust company, to be able to act as your voice and be able to ensure that the documents that you put in place are appropriately respected. I think that can go a long way to ensuring that what you get is what you had intended.
It's putting the plan in place and then making sure it can be executed in the way that you want to.
Absolutely.
And finding even executors in some cases where, with older couples, you might have someone maybe who's too old to be the executor to do things in the right way. So estate planning lawyer, working with an advisor, talk to people, get this planned out.
There are people who specialize in this area. So STEP, the Society of Trust and Estate Practitioners, there's a designation, the TEP designation, that indicates that somebody is an expert in this field, that this is what they specialize in, and they understand the nuances of trusts and estates. So ensuring that the professional that you're working with has that expertise and then is working with your other partners, so working with your financial advisors, working with your insurance advisors, working with your team of advisors to be able to bring that solution and ensure that everything has been considered. But working with people who specialize, I think is a good idea for this.
It is a good idea. Nicole, thank you so much.
Oh, my pleasure.